So before I begin, I would like to acknowledge the traditional owners of the land we meet on and pay my respects to elders past, present and emerging. I'm currently on the Gadigal land of the Eora Nation. Massive welcome everyone to Everything Real Estate. I'm really excited about today actually. So thank you for joining us all today to talk about safely and successfully exiting rental properties, as well as accessing rental properties for clients. We know that housing is a critical part of healing for our clients, a place of safety where they can rebuild their lives. However, we also know that finding a safe and affordable house can be really difficult. Many of our clients, by their own choice, or more often than not, through a lack of social or community housing options, will be looking into private rental markets for their next home. As some of you may know, and I hope you all do actually, over the last 18 months, Domestic Violence New South Wales has been working in this space as part of the Safer Homes programme. We've heard from services how difficult it can be for clients to safely exit private rental tenancies and use the new DV tenancy legislation. We've also heard how difficult it is for our clients to attain private rental properties due to the barriers and the discrimination that exists. We've spoken with real estate agents and know that these barriers can be overcome, especially when there's a willingness to help. Today, we've proudly brought together 3 knowledgeable and experienced experts from different organisations and sectors to give us the most up-to-date information and insights. They will share with us their knowledge and expertise on how to use the new DV tenancy legislation to leaving existing private and rental properties without penalties. They will speak to the financial and rental support or assistance that is available to help clients maintain a private rental property, and how to best work with property managers to help clients get into the private rental property. So after all of our experts have spoken, we'll open the floor for a question and answer, which Pip's going to help me with, and I'll just basically guide through the chat box and see how we can assist you all. So we'll have quite an interactive session after everyone spoke. So firstly, I'd like to introduce and welcome Cass Wong, who is the litigation solicitor at the Tenants Union of New South Wales. Cass has been with the Tenants Union since 2013, so I'm sure has a wealth of experience and knowledge to share with us today. She has a Master of Laws and Bachelor of Law Commerce from the University of New South Wales. Cass will talk to us about the recent changes to the New South Wales tenancy legislation so that we can help clients leave tenancies where they are experiencing domestic and family violence without having to pay break lease fees, rent or property damage costs. So really looking forward to this. Welcome, Cass.
Hello. So should I start?
Please do, thank you.
All right, okay. So I might share my screen because I've got a PowerPoint presentation, and just bear with me. And let's see if that works. Can you guys see my screen? All right, alrighty. Thank you, everyone. I'd like to also acknowledge the Gadigal people of the Eora Nation, on whose land I'm presenting from today. I pay my respects to elders past and present, and also to all Aboriginal and Torres Strait Islander peoples here today. This is beautiful country. This is Aboriginal land, always was, always will be. I acknowledge that, and sovereignty never ceded. So today we'll talk about some of the protections that are available under the Residential Tenancies Act. Now, I have a quick agenda. I have been asked, let me see if I can get this right. Can you guys see that? All right, so just quick agenda. I'll quickly give a summary of some of the protections that are available under the Act, and the relevant piece of legislation that we're talking about here is the Residential Tenancies Act. And I'll speak more in much more detail about the protection in terms of ending a tenancy using a DV termination notice, and the types of evidence that needs to be attached to the DV termination notice in order to validly end the tenancy. And then I'll also talk about some of the other resources and where you can find further information, and including how you can contact us in the future. We do have an advice line that runs every day between 10 and 1 and 2 to 5, and I'll provide you guys with the number. So you guys can contact us if you've got any questions or if there's something here that, you know, we haven't touched on today.
Thanks.
Yes.
I'm so sorry to interrupt you. Sorry.
Yeah, sorry. No, that's all right.
And would you mind putting the slideshow on? Because I think a couple of our
All right, slideshow. Okay, let's see.
You.
Let's see. I've been taught how to do this. My colleague Patrizia, who usually helps me out with this, is doing another training at the moment. So, can you guys see? Okay, great. Thank you. So, just a very quick rundown. The previous prior to February 2019, what was in the Residential Tenancies Act was wholly inadequate. It only allowed a tenant who is in circumstances of domestic violence to end the tenancy without a break fee or compensation to the landlord if they have obtained a final AVO. And we all know that that's not everyone gets to go through that process in a very smooth way. And it is a process that takes quite a bit of time. And so there was quite a bit of law reform that happened in the years before 2019. And in late 2018, the legislation was amended. And the amendments came into operation in February of 2019. So we've had these protections now for some 2 years. And in between these 2 years, there were quite a number of amendments that happened over time as well. And some of the amendments that happened included the expansion of the protection against liability for damage to premises caused during the commission of a DV offence. Those are sections 54 and 54A of the legislation. And more recently, and this is only back in December of 2020, we saw the expansion of the competent persons, which is defined under the Act as persons who are able to make a declaration saying that a tenant is in circumstances of domestic violence. So I'll talk a little bit more about that and show you what the form looks like. Now, next slide. So, quick overview of the protections. There are three most significant pieces of amendments in the Act. First is the right to give a DV termination notice, and once you serve a valid termination notice, attaching the correct type of evidence that ends a tenancy by operation of law, rent liability ends, and the victim survivor will not need to pay any break fee if they're still within the fixed term. The second protection is the liability for damage caused during the commission of a DV offence. If the residential premises were damaged as a result of that, they're protected from liability. And the third protection is the restriction against listing on a tenant database for those tenancies that have ended ended early or ended because of DV. And when I say terminated due to DV, what I mean specifically is the giving of a DV termination notice, a valid DV termination notice. So, this is really important because even if you do have a declaration form from a competent person or a DVO, that on its own won't end the tenancy. The tenant will still need to serve a valid termination notice to the landlord or agent. And if it's a co-tenancy, it needs to serve the termination notice to the other co-tenant. The termination notice must specify a date that is on or after the day on which the notice is given. So what that means is it cannot be backdated. So if the commission of the DV offence happened 2 weeks before she wants to give the termination notice, it needs to specify a day that is on the day it's given. It cannot specify a date 2 weeks before. So, and then the legislation defines a person who is able to access these protections as a person who is in circumstances of domestic violence, And in order to prove that a person is in circumstances of domestic violence under the Residential Tenancies Act, you need to show it, attach one of the 4 permitted types of evidence, which is listed there, to the termination notice. And the 4 permitted types of evidence is the certificate of conviction, a copy of the DVO, a current DVO, a current family law injunction, or a declaration by a competent person. Now, you'll see that this declaration, is up there along with a court order. So you guys, and I think some of you will have the ability and are considered a competent person who is able to make this declaration. So it's given quite a bit of weight. It's just as, significant as getting a DVO. So the declaration by a competent person, where do you find this form? I might just show you where that is. I don't know how I can do this. I think I've done it right. So this is the competent person declaration. Can you guys see this? Yep. So this is on Fair Trading's website. Look now, this form is not overly long. It's only 6 pages altogether. And the relevant parts for a person who's able to make this declaration, really, you only need to complete part 1. You see that, you set out the client's details, their address, and then specify who the perp is, what the relationship is with the perp, the tenant that you're seeing in the perp, what the relationship is, and then your declaration. And you'll see that the declaration that you guys can provide. And so speaking of the expansion of the competent person list, previously when the amendments first came into play back in February of 2019, there was only one class of competent persons who can make this declaration, and they're registered health practitioners. And what we saw was some GPs were not willing to make this declaration, maybe because, they're running a really busy practice, or they don't want to get involved, or they're not trained or skilled enough to make these sorts of assessments. So that changed in December 2020, and we saw the competent persons, the definition of competent persons expanded to 5 other categories. So registered health practitioner is still up there, a registered social worker, an employee that works in government agency that provides child services, an employee that works in a non-government agency that provides refuge or crisis accommodation services, or you guys, a non-government agency that provides services to victims of domestic violence. And then the last category is people who have been approved to be able to provide counselling services under the Victims Comp scheme. So where you can find that list is up here in this really simple form. So who can make this declaration? Right. So you'll see registered health practitioner, registered social worker, employee of a new government agency that provides services relating to child welfare. That, and I think you lovely folks would probably fall within this category. And so you'd be in a position to make this declaration for the tenant. So, so just going back to the form itself, once you have your consultation with the client and you form an opinion that they're in circumstances of domestic violence, you can then make this declaration. And really all that's required is for you to set out which category you're in, when you consulted with them, and you making a declaration that on the basis of information obtained from the tenant and observations made in the course of that consultation, I have formed the view that the tenant is a victim of DV perpetrated by the person named above, which is up there. So ex-partner or the other co-tenant. And then that's it. That's it. And then part 3A is your details. Oh, sorry, part 3. So you guys would fall, if you're a registered social worker, you put your details here. Or if you're in the other category, in part 3C. And once the tenant has got a declaration, I might just go back to my slides. I hope this works. Yes. Once the tenant obtains a competent person declaration, it should be annexed to a DV termination notice that is given to the landlord and agent or agent. As I said before, the DV termination notice will end the tenancy by operation of law. And if it's still within the fixed term, the tenant does not have to pay a break fee or any other compensation. And there are additional protections, as I said, from the victim being listed on the tenant database. So here at the Tenants Union, we have painstakingly come up with a sample termination notice. It's available on our website, tenants.org.au. We've also got fact sheets and other resources there, and the headings for those, I think, is just DV and tenancy law. We're in the process of updating our fact sheet, so it's going to be much more clear as to when the person can show that they're in circumstances of domestic violence. So termination notice is really important. Like I said, having a copy of a domestic violence order or a conviction of the DV offence, that on its own, or declaration from a competent person, those things on their own won't end the tenancy. The tenant needs to give a DV termination notice in order to access the full suite of protections under the Act. And so the termination notice need not be overly complicated. All really it needs to say is, as I'm in circumstances of domestic violence, I give notice that I shall cease to be a tenant of. What needs to be in the termination notice is a date, the residential premises, and the date meaning the date on which vacant possession is intended to be returned to the landlord. Now, if there are other co-tenants in the tenancy, the victim survivor could still give the termination notice and their share of the tenancy ends. So I've heard of cases where agents have told victim survivors that they still have to pay rent or that they have to pay a break fee. That's wrong. And if that happens, we would recommend that a complaint be made to Fair Trading because the protections are there and it's quite clear. It's to protect the DV victim survivor, and representations made about you still need to pay rent. That's unlawful. So importantly, the DV termination notice must attach DV termination notice that is given to the landlord or the agent must attach one of the permitted types of evidence, one of the four. And for our purposes, probably the most used form is the declaration by a competent person. Now, the declaration by a competent person, if this is contested in the tribunal, and we've not seen any so far in the 2 years that this has come into operation, where the landlord has contested the veracity of the declaration. We've not seen that. And that is because the DV declaration, the tribunal does not have powers to actually go behind the DV declaration to actually make or form their own opinion about whether DV occurred or not. The declaration cannot be tested in the tribunal. Though it must be said that you guys are charged with, quite a bit of power. You know, it's considered just as valid and just as important as a court order. So use those powers, you know, wisely. And it is still an offence to provide a false declaration. It's set out in the Residential Tenancies Act, but I won't go too much into that right now. So hot tip is that, you know, I've said this before, and this is, I've got an ex-colleague who now's work in DV, and one of the things that she said to me is, you know, to make mention of this a few times, which is that the DV, the declaration by a competent person, you know, that 6-page form on its own won't end the tenancy. The tenant would still need to give a DV termination notice. And I say this because I have seen a tribunal decision where the tenant, it wasn't even a DV declaration, it wasn't a competent person declaration, it was a DVO. She's got a current DVO against the PERB, and she thought that that was enough for her to end the tenancy, and the landlord then pursued her for a break fee and other liability, so damages to premises and all of that. And unfortunately for that tenant, because she did not give the DV termination notice pursuant to the Residential Tenancies Act, she did not have those protections. And so the tribunal found against her. She had to pay a compensation in the form of a break fee to the landlord for ending the tenancy early. So cannot stress the importance of giving a valid termination notice. So I think, so I'm running out of time, but I'm happy to receive any questions, and you guys can always contact us. So our details are up there, tenants.org.au. We've got the DV fact sheet, the DV termination notice is up there. The Fair Trading's website will have that declaration form and then information for practitioners. So it's all in that 6-page form. Women's Legal Service New South Wales has got some really amazing publications up there, and there's one on a toolkit for GP, and it's a toolkit that they've created for GPs when they are in consultation with a DV victim survivor, and to provide them with a structure as to how to come to a view if a person is in circumstances of DV. It's a really structured way, and I would recommend that you guys could have a look at that. So it's on the Women's Legal Service, their website, and there's a whole lot of other really amazing stuff up there. And Law Access, where you can find information on the AVO and on our advice line. Our advice line runs every day from Monday to Friday between 10 and 1 and 2 to 5, and that's our number there. Thank you.
That's a slide I want to stay up forever. A lot of really important information there. Thank you so much, Cass, and some really interesting insights for our members. We'll be definitely making sure, I mean, this is being recorded anyway, but I think it'd be great, Pip, if we can just grab some of those resources and throw them in the chat box. Thank you. And yes, Women's Legal are fantastic, and we really value our collaborations with them. Yeah. Thank you so much, Cass.
Thank you.
That's really helpful. So next, I would like to welcome and introduce Lauren Wilson, who is a Senior Project Officer at DCJ. Lauren has worked for DCJ for close to 15 years in various roles, and for the past 3 years has been the subject matter expert in private market assistance. In her role, she's responsible for managing new and existing private market assistance products, including Rent Choice Start Safely. She's continually looking at ways to help break cycles of disadvantage and support people to live independently in the private rental market. Lauren will talk to us today about the rental assistance products that are available to women who are looking to move into private rental accommodation, including some of the more recent updates and products. Welcome, Lauren, and over to you. Thank you.
All right, so I did have a helper here with me today, but she is not in. So I'm going to try to share my screen, read my notes, a lot of information. So sorry if technology and me have a little slip up. So I'm going to share. All right. Is that? Can Can you see my screen? Anyone?
No, we can't.
No. Why is this not working? Okay.
Oh, yes.
Yeah. All right. So I created this package with the thought that it may be distributed to you all. So there are some slides that I have in here because it's useful information for you to have, but I'm not going to spend a lot of time talking about products that aren't really directly resourced to support people in the family and domestic violence space. Firstly, sorry, I will acknowledge the land that I am on today in Ashfield, which is the Gadigal land of the Eora Nation, and I pay my respects to those past and present and emerging, and all of my peers in the room that may be Indigenous. All right, so private market assistance in our space is any form of assistance where we're supporting a client of social housing not in stock that's owned by us. So it's pretty self-explanatory, but just that's the definition. So Rent Choice is probably our largest private market assistance or private rental assistance product. Is the paper rustling noisy on your end, guys? With that when I'm flipping pages? No?
No, it's fine. Thanks, Lauren.
Okay. Rent Choice products are a form of private rental assistance that support clients to access safe and affordable housing in the private rental market. Rent Choice provides a tapered private rental subsidy for up to 36 months, help with access to support services, including training and employment opportunities, and $2,000 in brokerage funds to assist a client in establishing and maintaining their tenancy, or to cover relevant work and study-related costs. Just to define what tapering means, it is at the 12-month mark, the client's rent contribution is increased and in 6-month intervals until the client at the end of that subsidy period is paying the full market rent. All right, so what are brokerage funds? It's up to $2,000 financial support to be paid to the vendor or service on behalf of the client. It is not a financial amount that goes to the client. So brokerage funds may be used for things such as services to sustain a tenancy or prepare for employment and training, assistance with training fees, course materials, textbooks and computers, employment-related costs such as work clothes, safety equipment, etc., household establishment, transport-related assistance, or cost associated with moving. Brokerage funds cannot be used for advanced rent or bond loans. I will talk about those products that we do have available separately to brokerage in some later slides. And we also can't use brokerage funds for rent arrears or gift cards. So there are 5 different types of Rent Choice products. We have Rent Choice Start Safely for those experiencing family domestic violence. I will note that Rent Choice Start Safely is not gender-based. It is available to both male and female and non-binary non-binary clients. There's also Rent Choice Youth, which is for people aged 16 to 24. And then Rent Choice Veterans, Rent Choice Transition, and Rent Choice Assist, which don't often target people in this space. However, they are products that are available to clients as well. So the Start Safely program, which supports people escaping domestic and family violence with up to 3 years financial assistance to find affordable housing in the private rental market. Rent Choice specialists conduct quarterly reviews to build a relationship with the client and to help them on their path to independence. At these reviews, we can link clients into support services to assist them with sustaining private rent and moving forward with their lives if required. This can include referrals to support agencies or to some of our internal support, such as opportunity pathways for employment opportunities. And it's important that we stay engaged with the clients to ensure that they are remaining safe in their current situations. Start Safely applies to clients escaping domestic and family violence who are homeless or at risk of homelessness. Clients in general must be escaping domestic or family violence, be homeless or at risk of homelessness, and they must be eligible for social housing. However, clients up to a moderate income limit, which is defined by the income tables for the affordable housing guidelines, can be approved if they are at serious threat of domestic or family violence, or they're identified at a safety action meeting. Okay. So how can clients apply for Start Safely? So they can attend a local office in person and request assistance. They can complete the application for housing assistance online or over the phone via our housing contact centre. There is actually a question in our applications asking a person if they are experiencing family or domestic violence, and that is a trigger to look at whether that client could be eligible for this product. And clients can also be referred through the safety action meeting or by a support service. So just for those who aren't aware, the safety action meetings are regular meetings of local support providers that aim to prevent or lessen serious threats of safety or domestic violence victims and their children through targeted information sharing. All right, so Rent Choice Youth. The Rent Choice Youth program has very similar guidelines, with the main difference being clients between the ages 16 and 24, opposed to the family escaping family domestic violence. There are some differences though. So each participant must have an independent support plan when entering the program of Rent Choice Youth. This plan steps out the young person's goals for stable housing, employment, education, and or training. Caseworkers conduct quarterly reviews in the similar spaces they do with Start Safely, to ensure that the client has the best chance of maintaining their tenancy on the path to independence. The priority groups for Rent Choice Youth are those leaving out-of-home care and or those who have experienced domestic and family breakdown. Now, the eligibility requirements for Rent Choice Youth are the ages of 16 to 24, eligible for social housing, able to live independently with or without appropriate supports in place, homeless or at risk of homelessness, engaged with a support service who are a member of the partner facilitation groups, and their willingness to engage in training, education, and employment during the period of the subsidy. Now, the clients must be referred to us through a partner facilitation group. And I'll just run through what they are. So a PFG, or partner facilitation group, is a cross-agency working group in which social housing providers chair the meeting and partner agencies, including youth services, specialist homelessness services, and other relevant parties or agencies are involved. The PFG assess any clients referred to the program, ensures that the quarterly reviews are conducted, and that the clients maintain engagement with their supports throughout to the life of the product to sustain their tenancy. There are a PFG set up in over 20 locations across the state. These PFGs meet quite regularly, and a list of all of those locations are available on the DCJ website. I won't go too much into Rent Choice Veterans. However, there is another Rent Choice product, with the main target group being those former or current members of the Permanent Australian Defence Force who are homeless or at risk of homelessness. They can have an income limit up to moderate, which is just again based on the affordable housing guidelines. We also have Rent Choice Transition, which is a program that could fit in this space. So it's if a client is currently a social housing tenant and they wish to move and they don't wish to go back into social housing. So we can support a person moving into the private rental market out of our social housing stock. This has been piloted in some locations. However, if anyone does express an interest anywhere across the state, they will be assessed on a case-by-case basis. And if we do feel as though that they have a good opportunity of being successful in the private rental market, by all means, we will support them. This can quite often happen if somebody's living in a metropolitan area and an opportunity comes up for them to go regional, or perhaps they want to go back to family. And it's affordable for them to live in the private rental market in those lower cost areas. We can support them with things such as brokerage to help with removalist costs, and with a subsidy to help them, moving towards housing independence. So the first 12 months, they would pay what they would pay in a social housing tenancy, and we will slowly taper off our contribution until they're paying that full market rent. It could be used in the space of if a person wants to leave an unhealthy situation and move to an alternate location that could have affordable rent, we can support them in that space. Okay. We also do have a trial happening at the moment in 4 locations called Rent Choice Assist, and this is for people who have experienced a financially destabilising event in their lives. It's currently being piloted in southwestern Sydney, Western Sydney, Murrumbidgee, Hunter and New England, and Illawarra. To be eligible, a client needs to meet the basic social housing eligibility, with the one variance being they can earn up to a low income according to the ministerial guidelines for affordable housing. They do need to demonstrate that they have got a history of successful tenancies, and they need to be willing to find private rental within 3 months of approval of the program. Examples of a financially destabilising event could be a family breakdown, it could be a loss of job, or needing to take time away from work due to illness or to care for a sick relative. Okay, now I won't go too much more into rent choice because I am conscious of time, but a client who is in receipt of a rent choice subsidy needs to be suspended on the New South Wales Housing Register for the period of their subsidy, excluding transition and rent choice assist, where they actually do need to opt out of being on the register altogether. All right, so now we will look at rent choice bond loans. Rent choice bond loans, rent start bond loans. So a bond loan, how do I go back? Goodness, sorry guys. I don't know how to, oh, here we go. All right. Bond loan and advanced rent. A bond loan is financial assistance for eligible clients to help them set up a tenancy. This bond loan does go directly to Department of Fair Trading. It does not go to the client or to the landlord. And to be eligible, you need to be eligible for social housing, have less than $3,000 in cash assets, have the ability to sustain a tenancy in the private rental market, and need to ensure that the private rental tenancy is not more than 50% of their total gross household income. To apply for a bond loan, you can go online or over the phone. It's a very fast process. We do have people working 24 hours a day, 7 days a week to process those applications. All right, advanced rent is not to be repaid, unlike bond loans. So it is actually grant, usually 1 week, and clients who are got at-risk factors, such as those escaping family domestic violence, can get up to 2 weeks advanced rent on top of their bond loan to secure those private rental tenancies. The eligibility criteria is the same as bond loans, so they're just all listed there. We'll move through. Bond extra is another form of assistance we can provide. Again, it's not a financial assistance, it's actually a bit of a guarantor. So it is something that we provide the landlord or real estate, saying that if at the end of a client's tenancy, or less than 12 months after they've commenced that tenancy, if there are any incidentals such as rental arrears or damages, we can pay up to $1,500 on top of that client's bond as a bit of an incentive to want to give clients an opportunity in that private rental market. Now, private rental brokerage service is a service at the DCJ. I'm just trying to read quite fast. I'm really sorry, everybody. So this service aims to assist clients in developing and enhancing a client's capacity to access the private rental market, with the client directing the process as much as possible so that they can build confidence and skills. This will be achieved by coaching, guiding, and supporting the client. And then to facilitate this process, staff will continue to develop relationships with the local real estate agents and landlords to improve their clients' opportunities in the private rental market. It is available in quite a number of locations. They are listed on the DCJ website as well. And I think lucky last, we do have tenancy assistance. This used to be called rental arrears. So for those who might have had clients use our assistance before, it's now called tenancy assistance. And this does provide once per year assistance to people who may fall behind in their rent. So clients who are in the private rental property and are not receiving a DCJ subsidy, so they're not already receiving rent choice, they can be assisted with rent and or water arrears. once in a 12-month period. It is up to a maximum of 4 weeks rent, and the landlord or real estate agent does need to write a letter of guarantee to say that if we pay this, they will not evict the client moving forward. Sorry for the very rushed presentation. We do offer such a great scope of private rental assistance products, and I just needed to try to give you a 20-minute presentation in there. So hope I haven't spoken too fast or made it too confusing to you all. Thanks.
So there's nothing worse when your teammate is unable to help you with all the page turning and everything.
That's okay. Sick kids are more important than presentations.
Definitely. Well, Lauren, you've obviously got a wealth of experience at DCJ, and I am absolutely certain that the members will want to do some questions at the end. So thanks for hanging on.
Yeah, that's okay.
And yeah, we've got this recorded, everyone, because there was a lot of information there to download.
Yeah, and I'm happy for that presentation, which I have provided to Louise to go to everybody. It does have some hyperlinks in there as well, and everything is available, quite easy to find on our DCJ website.
Oh, that's amazing. Yeah, all the information as possible. Thank you so much.
Not a problem.
So last but certainly not least, I would like to welcome and introduce Alexandra Haggerty. Alex has been a dear friend to Domestic Violence New South Wales, and indeed several services across the sector for a number of years now, and has been hugely supportive and a massive advocate for the clients in that time. With over 20 years of experience in real estate, Alex is a subject matter expert in real estate and especially in private rental property management. In 2015, Alex initiated a relationship with her local domestic and family violence service that, over the past 5 years, has enabled many women to successfully enter the private rental accommodation in the Maitland area. So we're really keen to hear about that, Alex. Alex will be talking to us about how to improve the odds of attaining a private rental, covering things such as working with property managers, getting the clients ready for the private rental market, attending inspections, what to say at inspections, how to prepare clients to attend inspections, lots there, rental applications with a property manager and how to look at the application process, and how to make a strong application as a prospective tenant. Thank you so much, Alex. Yeah, I'll open the floor to you, and welcome.
Thank you. And I'd like to also acknowledge the land that I'm on today, in Minderibba lands, and the elders past, present, and emerging. So I guess the first thing I'd check in. So, okay. The market at the moment, particularly the rental market in rural New South Wales, are we New South Wales only here, Talia? Yep, okay. So particularly in rural New South Wales is red hot. We're finding so many applications for every rental property that is becoming available. We're finding tenants that have an existing tenancy not giving notice because it is difficult for them to find something else to move into, which has meant that the numbers of stock changing over is really limited, and the number of people that are leaving the capital cities and coming, or cities in general, and coming out into regional New South Wales means that we're getting a lot more applications for each property that is available. Last month we were averaging 67 applications per property. So when you consider the sheer numbers of people who are applying for the very few properties that are available, the landlord can only pick one tenant, which means that unfortunately in this market, a lot of the clients that you guys will be working with are getting overlooked for probably what on paper looks like a more settled tenant. So it's really important to make sure that in the application process that you're making sure that the client looks as strong as possible. I guess the other thing that before we get into how to get actually into accommodation is the client might want to really explore the possibility of making the home that they're in, if that is possible, to make that safe and remain in their existing accommodation, because it is very difficult, particularly if that client is not at threat of imminent violence, if they have previously left violence and are looking to move on to another property. It can be very difficult to secure that accommodation, and if at all possible, with products like staying home, leaving violence, if it's possible to remain in that home and stay safe, that may be a better option at the moment, because it is just so tight, and it's tight across the board for every tenant that's applying for properties. But as you guys know, especially tight for clients that you're probably working with. The first, I guess, once you make a decision that yes, that client either has left their accommodation or needs to leave their accommodation, and we have to get them into a new property, the first thing that you need to be very mindful of is that the market is red hot. So you need to be incredibly prompt with everything from responding to messages, getting your application in, booking a time. As soon as a property becomes available, make sure you're booked in. There are products on realestateanddomain.com. You can actually set up a profile of what you're looking for in a rental property using those search engines or satellite sites, and you'll be notified as soon as a property that matches that criteria comes on the market. What I would suggest is that you either, depending on how the agent is working at the moment with COVID, either book straight into an inspection as soon as the property becomes advertised, or apply for the property immediately if they're taking applications before they're showing people through, because it really is the people in the first couple of days that are really only getting any look into viewing the property or getting their application really looked at. And then once you do have a time, if they're getting back to you over perhaps the tenant that's living there has had to change the time, or if they're getting in contact for you for whatever reason, make sure that you're incredibly prompt with it, because there are just so many people lined up behind waiting to get into that property as well, that you know, we worked with a client not that long ago, and we were doing our best to try and get her into a property, but the message came back, oh, it'll be 2 days before I can get to you with that information or something like that. The property's gone by then. They're moving so fast that there isn't the opportunity for that. The landlords want to know that they're getting their property leased immediately, and that they've got a tenant lined up to go in, that there's a holding deposit paid. So that can mean the difference between a client getting a property and not getting a property. At the moment, it can be just that the agent is not waiting for something from someone else, and that literally can be the difference when you're getting that volume of people wanting a property. It comes down to the tiniest things why somebody is getting approved over someone else. Then, so at the moment, also I should probably explain, some agents due to COVID are getting clients to fill applications in and apply for the properties before they've viewed the property. We're getting a little bit, our office is participating in that as well. We're getting a little bit of mixed feedback, mostly positive. With that, some clients are irritated that they've got to put their paperwork in and apply for a property before they have a chance to view the property. In response to that, the reason that a lot of proactive agents are doing that in this environment is the sheer numbers of people who want to see the properties versus the client and the tenant that is already in the property. If you can imagine, you know, if 60 odd people are applying for property, we may have over 100 that want to see the property. It's just not feasible in the COVID environment to be asking somebody who is still residing in that home to be having that number of people coming through, and it's not respectful to our existing client that is in the property. So a lot of agents are now getting people to apply for the properties, and then the owners are presented with that information, and the owners are selecting which ones they want to go through and inspect. And we may take six clients through that are almost not pre-approved, but they're sort of finalists. And then of those, whoever wants to go ahead with the property, that's who the owner is picking from. And it's just a way of being able to manage the sheer numbers and limiting the number of people that are actually going through the properties at the moment. So that's why you may see a change in your clients and how they are either viewing or inspecting or applying for properties. That's why we're doing it, and that's why you're seeing more of it. With that though, most agents are going with a paperless application process now. So as caseworkers, the benefit of that is that if a client is applying for a property, then and they're doing it online, which I suggest that you encourage, they set up a profile of themselves and attach all their information to that. And then they link their profile to different properties. And depending on which software the agent uses, they can find that once they've set their profile up, that different agents in the town will be using the same software, and then they just attach their profile to the different properties, which means that they've only got to put the paperwork together once. There's probably only 3 leading companies that we use as agents, as an online way of managing applications. So if you're lucky, even if you've got to get someone to apply for multiple properties, you may only have to set that profile up 3 times, and then you can apply for as many properties as are being used through those softwares, because you literally just link your profile then to each property. So it may not be a bad use of your time as a caseworker and help the client is to sit down and create that best looking profile for them. So then it's just a matter of when a property comes up, bang, you just link it to the property that they're applying for. On those applications, it's incredibly important to make sure that everything that the agent is asking for is filled in, which can be really difficult with the clients that you're working with. Obviously, there can be issues with being restricted access to financial documents or identification documents and things like that. So I really understand that can be difficult, but that is one of the things that, particularly if you don't have a relationship with an agent in the town and can't or don't want to disclose the history of the client, holes in applications generally are an indication of previous homelessness. And if that's not disclosed and there's not some supporting evidence and information backing up what the reasoning for that homelessness, like it could be as a result of a previous tenancy that hasn't ended well. And without those references to be able to establish what that means, it's a red flag that is being highlighted and identified in applications. So that's why it's critical to have as much information as possible and fill in as much of the application as possible, so that the application doesn't have those holes in it where an agent may look at it and think something's gone. We can tell in an application going back history. And if those holes are being identified, it just throws question marks on it and you move on. Especially in this market, you just move on to the next client. So as much as possible, can make sure that application is as complete as possible. On that though, one of my favorite sayings when I work with clients, DV clients that are referred to us through our partnership, one of my favorite sayings is, sometimes when the door's locked, you can get through a window. The application may say that they're looking for one particular piece of supporting evidence, but if you're able to have a look at what are they asking for in that application, what is the purpose of asking for that piece of supporting evidence, you may be able to prove the same thing with a different piece of supporting evidence. So an example of that may be, say a tenant excuse me, was in a private rental and they were getting, and the rent receipts were being sent to the partner, and the victim survivor didn't have access to those rent receipts to be able to prove that the rent was being paid on time. That's a barrier at being able to prove rent. So the purpose of that piece of supporting evidence is to be able to establish that the rent was paid on time. Now, if you're in like being rented through an agent, then the agent would simply print off your tenant ledger. But if you were through a private landlord, generally that's not as easy to, you can't just print. They don't have the software that we have to be able to just print off a tenancy ledger. So if they didn't have access to the rent receipts, well, we think, okay, well, how else can it be established? You may be able to establish that an automatic direct debit was being put into another account. So you may be able to print off a copy of the bank statement. And even if you black out all the other information and just show the dates and the amount and that it's a regular payment that is going through, then that may be enough to suffice what the agent's asking for. So if you are able to have a look at what the evidence is that they're asking for, and then what is the purpose of asking for that evidence? And then is there a different way that we can show exactly the same thing? Another piece of evidence might be, so quite often you're asked for proof of address. Now, the purpose of proof of address, so we're asking for something that's being mailed to the address that the client is saying that they're coming from, of where they are now. The purpose of that is to prove that that client actually does live in that property, that they're not just saying that they live in that property and they're actually somewhere else and there could have been an issue with that tenancy. The point of it is to establish that, yes, the person was living there because mail is being sent to them there at that address. So that's why you might be asked for a phone bill, a power bill, in that name. Now, obviously, with clients that you guys are working with, a lot of times that won't be in the survivor victim's name because of controlling issues and that sort of thing. So if the application is asking for a utility account in that name to be from that address, and you can't provide that, you may be able to prove a different way. It could be on the car registration. If the car is registered to that client and the address on the registration form is on there, could be Centrelink documents that you'd be able to just print off. Even though they don't get posted anymore, they still have the address underneath of where is registered to that client. It could be, you could go and print off another copy of the bank statement, and the actual statement has the address of what is the registered address on it. So there are different ways of being able to take information that is being looked for and replace it with something else. The next thing.
Sorry, Alex, I was going to say we're about to hit 2 o'clock. So
okay.
There's a couple of maybe a couple more minutes if everyone can hang on, and we've then got a few questions in the chat box that we might follow up on. But yes, a couple of minutes would be great because all the practical stuff's so helpful. Thank you. You're
welcome. Okay. Really quickly, make sure all the products that the tenant's eligible for are pre-applied for and ready to go. So if they're eligible for rent choice or start safely or staying home leaving violence, all of those, anything that they're eligible for, if those applications can be done beforehand, so that when you're putting the application in, you can let the agent know that this client is coming with all of these support products, which makes them a better option than another tenant off the street, that you don't know the history of what's going on with that client. And really, the support worker can be a really good advocate on behalf of the client, but at the same time, the client needs to be the one that's engaging with the agent so that they don't come across as not able to maintain the tenancy on their own after they're getting the support as intensely as they are at the start of the tenancy. It's also really important to make sure that they only apply for properties if there's a chance that they're going to get it. Every time a tenant applies for a property, their name's run through a TICA, which is a tenant database. And when you run someone through TICA, it records who put them through TICA and the date. So if somebody is applying for property after property after property after property, not so much in this market, but in a regular market, and then not being approved, as soon as we put them through TICA, it will tell us how many other times they've applied for. And it is a little bit of a red flag to think, well, why is this person applying for properties over and over again and they're not getting it? And we can have a look at it and then maybe start to delve a little bit deeper into the application. So to not red flag that at the point of applying for it, it's really important that you I'm not saying don't apply for properties, but if that property is outside of their affordability, there is no point to them applying for it. If the property is a 2-bedroom villa and it is a mum with 4 children, that's never going to be approved. The landlord's wear and tear on that property, and if there, God forbid, happened to be trouble at the property and it went to tribunal, the tribunal member then comes back to the agent and says, you approved that amount of wear and tear on the property. You knew the number of people that were going to be there. So it's important that you identify if that client is likely to be successful for that property before you make a decision as to whether to apply for it or not. And on that, I know that housing and some other government departments consider up to 50% affordability. Within the private rental market, we consider 30% affordability. So it is a very big difference and then on top of that, you can have your support products, which are available. So big difference can make a big difference to what you're applying for. So that is really important. The other thing is, really quickly, that we have a partnership with our local service provider, and how that works is the service provider, as part of the, I don't know, is it an induction process or an intake process with a client, they assess whether that client is likely to be successful in the private rental market. If they establish that that client, yes, would likely to be successful, they have the affordability, they may have a rental history, or for whatever reason they feel that that client would be successful and could be easily rehomed, then they refer those clients to us. We give them access, priority access. We have an understanding and training, the staff have an understanding and training of what the products are, what they mean. We're able to then give all of this information to the owner, which then the owner understands that that client could actually be a better option for them than just somebody that they don't know the history of their circumstances, because they have support products. We are able to understand, explain to the owner what the support products mean, especially the financial ones. But the key thing to our partnership working is that we have access to the caseworker for the duration of the tenancy, which means that if something happened down the track and the tenancy became unstable, we could reintroduce the caseworker to that client, because quite often by that stage, the caseworker is not working intensely with the client. They can come back in, and the two, between the agent and the caseworker, we shepherd the tenancy back on track, which helps the tenant be able to stay in the property. And they may need access to more support products. It may just be a matter of the support worker reiterating what the agent's saying for whatever reason that the tenancy is becoming a little unstable. And if we can keep that client in the property instead of having to terminate and the tenant have to then try and find accommodation again, it is a much better outcome for the client, because they don't have the expense of moving, the stress of finding something else, nothing available, especially if they've got a termination notice. What is that termination notice about? They may have trouble finding something else to move into because of it. So it gives that landlord a little bit of protection for the duration of that tenancy, and more likely to look at taking that tenant on.
We're definitely going to be sending a recording round about that. There's some really good practice examples there, and the collaboration piece is so important. So we have lost a few of you, but really quickly jumping on questions just to round up. We'll go to, if we can, 2:15, if that works for everyone. And again, no offense if you will drop off, but wonderful to have Lauren, Cass and Alex with us today. So first question is from Tali to Cass. You may have seen it, Cass. Cass, could you clarify the date on the form and the before or after leaving timing? I was just a little confused. Thanks, Tali.
Sure. So the form, I think you're referring to the declaration from a competent person. So that form, the dates that are required there is the date you've consulted with the client and the day you actually make the declaration. When I talk about dates on the termination notice though, the termination notice needs to specify a date that is on or after the day the notice is given. So what that means is, if you give a termination notice today, it must specify today's date. It cannot be backdated. It must specify today's date or a date in the near future, but not backdated.
And
That clear?
also be the date that possession is handed back.
That's right. Thanks.
And Sarah, you're here, fantastic. Do you want to just quickly summarise your question really quickly to Lauren? Thank you.
Hi. So really quickly, up in our area, we struggle sometimes around the start safely requirements. The one particularly around needing to support the woman for the entire time she's on start safely, which is 36 months. We, of course, best practice would love to support women for 36 months, but sometimes it's just out of our control. We might have women that exit themselves. They don't feel like they need our support any further. Yep. Or, of course, we only have a couple of caseworkers in every area and so many women needing support that our staff members just don't have the capacity to hold on to people for 36 months if case plans have been met and people aren't needing our ongoing support, which is, of course, what we're trying to achieve. And that doesn't count if women come back into our services, of course, if they need us again. But yeah, we're really stuck at that point of that's 36 months out of our control. So I just really wanted to kind of get your opinion on that. Is that a hard and firm?
No. So, I mean, the whole purpose of Rent Choice is about helping people meet goals to essentially live with housing independence. And that is about social, financial, and housing independence at the end, if they are following that independent support plan correctly. Look, if a client is deemed as no longer requiring support, it's not a prerequisite for them to be continually supported through the subsidy for them to be engaged with the support agency. As long as it's a little bit different if the client completely disengages from the support agency, they are finding themselves back in a space of trauma and it's quite difficult and they're sort of falling through some gaps. That's a different situation. But if a client has met some goals and they're feeling stable and they don't need support anymore, they don't need to continue to be engaged with you.
Yeah, okay.
Some sort of communication towards the social housing provider as to why they're disengaging is obviously preferred, so we can document that on a client's file. And if a client does fall back into a space of requiring help, having that ability to have that recognised on the file of who they were engaged with and re-engage them, but continual is not required.
Okay, great, fantastic, thank you for that. And one last quick little question. The ISPs, is that a must for Start Safely as well as the youth subsidy?
Look, it's not as crucial, but it is the independent support plan. It's something that we're currently reviewing, and I don't want to bore everyone with the internal details, but the independent support plan is to identify goals, whether it be social, emotional, education, financial, whatever it is. And when we conduct those quarterly reviews to ensure that that client is on track, we need to have something to go back to. It doesn't have to be the formalised independent support plan from DCJ. If you're an agency working with a client and you have set your own goals and you've got a little case plan for that client, providing something like that is perfectly fine. It doesn't have to be on our format. It's just quite often with youth, we like it in that format because it's consistent across the state because they're being supported by a third-party agent. But if anyone is supporting a client and they have their own case plan for that client, or perhaps the children of the client or whoever it might be, that's fine as well, as long as we have something to measure the client's success towards in order to progress through the program.
Yep, great. Thank you so much, Lauren.
Not a problem.
Good question, Sarah. And final question from Tali.
Do you want to ask it, Deals, or I can do it? I was just asking around housing. DCJ requires people to apply for a lot of housing properties, and what Alexandra was saying was that if you apply for too many, it works against you. So I'm just seeing a real conflict there, and it could actually put clients behind.
Absolutely, yeah. Look, I don't know what the answer to that is, but yes, definitely. I understand that they are required to apply for properties, but yes, it is actually putting them in detriment.
Yeah, and to be honest, from a DCJ support perspective, and I'm not speaking on behalf of the department, I'm speaking part of myself, that I've not actually known that. Even as a person trying to enter the private rental market at times myself, I did not know that every property you apply for is recorded. So it is something that perhaps, next time the discussion is open for ways to support people who are trying to escape homelessness and the processes that we're enforcing on the front line, it's something that I'll definitely raise and make sure that people who are making those decisions are also aware of that.
I think that's why the Safer Homes programme is so important, because we get to share information in this space against, across different organisations. So thank you, all of you, Cass, Alexandra, Lauren, thanks so much. That was fantastic. We'll be following up everyone with a recording, and thanks for the awesome questions as well. And we'll keep this conversation going because I think we need to. And there was so much shared, but thank you again.